initiatives, including the L-Leap project, designed for Six Sigma and the ACME program, is landmark contribution, the design and the implementation of a role-based HR organization with a six-pillar framework has significantly impacted holistic company growth. His strategic leadership and unwavering values continue to be a cornerstone of Revantha's success. Meanwhile, I would like to invite Mr. Rasappan sir to share few words regarding this webinar.
Thank you, Manisha. Thank you for your nice introduction. Is it audible to everybody? I hope. I'm delighted to have you all here for this webinar hosted by our LCS team. So really, it is a very honorable moment for us to have all the HR leaders with us to discuss about the HR labor laws requirement, also statutory compliances requirement, any other HR points related to the compliance area. Really, we are interested to address those points. We have a veteran, Mr. Ravi Shankar, with us to deliver the keynote address and the presentation on the labor laws requirement for the new age labors, new age HR leaders. The important momentum here is that I'd like to emphasize 2-3 points here before ask Mr. Ravi Shankar to give presentations. HR domain basically an important domain in organization to bridge between the employer and the employee, also the stakeholders of the government or the statutory bodies. So it's a triangular connect, which is really a very very strong hold we must have on the forum. So especially when we're talking about the employer side, the organization development, the employee value addition, the profitability, what we are making through the resource effectiveness, those points has to be addressed for the employer. Coming back to the employee, the benefit of employee, the engagement of employee, the career growth of an employee, or the employee giving a great experience to the employee, those points has to be addressed to the employee. If you come back to the stakeholders like maybe a customer, maybe a government bodies, or maybe the society, we have to emphasize on the compliance with the statutory laws and the compliances, on the social security to the employee, which is enforced by the government. Also, the work environment has to be provided to the employee. It is mandatory by the law. Also, the equality, gender equality, or any other harassment issues, those things are mandatorily required by the law, and that has to be implemented in the organizations. As a HR leader, our role is very critical here to connect these three pillars. So what is the role of how we are going to contribute for employer, how we are going to contribute for employee, how we are going to satisfy our compliance with the requirement of the stakeholders or the government. So those points are very critical when we are understanding the statutory requirements. So my emphasizing point here is, while understanding the labor law requirement or statutory requirement or any societal requirement or the code of conduct, whichever may be the point, we have to connect those points with the employer perspective, and the stakeholders perspective. So when we are connecting this way, the real picture or the phenomena of HR can evolve. So that's the way we have to look into. So here we are here to discuss the labor law requirement. It may be a registration, or it may be a display, or it may be a submissions, or it may be a regular report gaining, all addressing the abnormalities arising in the organizations, or noticed by the government issues. Any of the points can be you can be questioned, and the solution will be provided by our veteran Mr. Ravi Shankar. If required, I can also intervene side by side. And any specific questions on SR side, any specific question on SR side, HR front, that also can be addressed to the team. So once again, thank you so much for the wonderful opportunity for me to have you all here. Also discuss certain points with you, all the HR leaders here. So I'm delighted once again. Thank for the arrangements by the our team. So let us discuss those critical points from right now. Thank you, Manisha, and thank you, team. Over to Mr. Ravi Shankar. Thank you.
Thank you, sir. Thank you. So now I would like to invite Mr. Ravi Shankar, the business head, Lakshmi Corporate Services, with over 15 years of experience in HR outsourcing. Mr. Ravi Shankar leads the corporate service division at Revanta Services. He has been instrumental in driving business growth and automation in compliances for top clients like Accenture, Goldman Sachs, and PwC, recognized by NHRD for his RPA innovations in payroll compliances. Mr. Ravi Shankar is a seasoned expert in labor law and statutory compliances. So let's get started. So now Mr. Ravi Shankar will be presenting the essential labor law for new age HR leaders.
So today, actually, we are going to know about the basics of labor laws. See, labor laws, anyway, that everyone knows that it is fall under important, but whereas not urgent category, and that is one of the reason many of the tasks have been missed by many of the folks. Um, so anyway, that thanks for the team who has joined, who has shown interest in this labor laws. It will take at least 2 days for me to complete the entire session, but till actually it is just 1 hour. So I'll just try to be specific to what it is being required for the HR to understand the basics. I'll stick on to that. And anyway, that you have all the privilege to raise your questions via chat, and there is a team working on it to understand the question, and that will be answered over the once the session is over. So it is labor law. It is nothing but it governs the rights and responsibilities of workers, employers, and the government. Uh, See, predominantly, actually, it will protect the workers' right and ensures fair jobs. Um, what is important in this labor law is one, actually, like there should be a harmonious relationship between worker and employer, and there through this industrial relation. And second, actually, there should be a safety workplace which is required to be ensured by the employer, and then there should be a standard, the employment standard, like working conditions, wages, and it talks about the working hours and the benefits required to be given to the employees, etc. It is a few things which it is probably everyone knows, but till the basics which I just explain here. Before getting into that, I'll just talk about the federal nature, how it has been formed. So there are central acts with common rules. Uh, so the example is Employees State Insurance Act, Employees Provident Fund Act, and Payment of Bonus Act. And there is another category where there will be central rules and with central act with central rules, and for central act there will be state rules. Say like example, Payment of Wages Act, Minimum Wages Act, and Payment of Gratuity Act, where you can see the acts are central and there will be central rules, but state rules, the state government is having all the rights to notify any rules. And there are third one is the state acts with state rules, where there will be only the state government can form the acts and they can form rules against that. That is Substance Establishment Act, Labor Welfare Fund, and National and Festival Holidays Act. And there are different category. Maybe one is the regulatory acts. So you can see that there are a number of laws it is available, but predominantly actually what we have to know about the nature is what is the nature of that law. See, say regulatory acts, it is, say example, Factories Act, it regulates the working conditions, shop and establishment, mines, plantation, Contract Labor Act, Building and Other Construction Workers Act. These are some of the examples which fall under the regulatory acts category. Second one is wages related acts. where there are a few acts fall under this particular category: payment of wages, minimum wages, payment of bonus, and equal remuneration. So we'll get to see each of these act over the period. So I'm just moving. And then the third category is employment and training, where Apprentices Act and Employment Exchanges Act are fall under this. Then there are social security and welfare, where employee state insurance, EPF, payment of gratuity, maternity benefit, and employees compensation acts are fall under this particular category. And then industrial relations, where ID Act, trade unions, standing orders, and the payment of subsistence allowances act. These are all fall under this particular category. Probably these are all informative. So the learning will be there in the next few slides. So we have seen some categories, and if we get into each and every act, then you'll find out that the applicability, objective, and then definitions, and a lot of the frameworks, the compliance provisions, etc. Everything will be there. But what is the simplified way to learn labor law? That is, one is to understand that the terminology which has been used in each and every law. Predominantly, it is for the HR. Actually, what we have to know is what are the category it is available, or what are the complaints it is required to be done under each and every labor law or every act. So one is the registrations, renewals, and amendment. You know that that is going to be the primary one, where any organization should be registered under various labor laws, and there are various registers required to be maintained, and filing periodical returns, remitting the statutory dues, and handling the inspections and notices received, and various displays, abstracts and displays required to be displayed. Then procedural, there are a number of procedures. Anyway, that we are going to see each and every this category in the coming slides. So registrations, renewals, and amendment. It is you know that there are Factories Act, there is a license. Shops and Establishment Act, there is a registration. Payment of Gratuity Act, there is a notice of opening record to be filed when at the time of opening of the establishment. Then PT. Labor Welfare Fund, Contract Labor Act, it is for principal employer, there is a registration, and for the contractor, there is a license. And EPF, there is a registration at the time of once it is applies, the registration is required to be obtained, and same way it is with ESI. National Festival Holidays Act, you know that whenever there is a the company starts or establishment open their offices anywhere else, and they have to file a notification to the department on the days, the National Festival Holidays Act, holidays which are required to be provided to the employees. And BOCW, there is a registration. Interstate migrant workmen, there is a registration. And private security agencies, predominantly it is applicable only to the security agencies. So they have to comply with all this provision of the Act. And the principal employer is, of course, they have to ensure whether they are complied with all the provisions of the Act. And India is moving towards digitalized, and you know that if you see that predominantly most of the states they have come up with the online solution where the entire registration can be obtained through online. That is for shops and establishment, even it is PT, factory, almost everywhere it is online, and there are offline too. So that has been mentioned over here. Labor Welfare Fund, some states it's applicable, some states it's not applicable. So similarly, it is there for PT2. So just a matrix where it's information which we have taken from taken for Pan India, covering shops and establishment, professional tax, factories, and labor welfare fund, which are the more these are more critical for any of the organization to comply. And the second one is the registers. The what we have seen is the registration part, where you know that everywhere there is a registration, and some act there is a renewal, and some there is an amendment. So that after this category, second one is the registers. So every organization they have to maintain various registers. It starts with the attendance, register of wages, leave register, register of fines, register of deductions, advances, OT, register of wages under Equal Remuneration Act, bonus registers. You know that Form C is required to be maintained, and Form A and B, of course, it is related to finance, and labor welfare fund registers, that is including unpaid accumulation is required to be documented over there. And national festival holidays registers where the employees, on the holidays which has been declared, and the wages paid to the employees are required to be incorporated in the document. And maternity benefit register where the human employee status is required to be updated. And there are returns. There are annual returns. There are monthly, quarterly, half-yearly, and annual returns under various labor laws, which is applicable to establishment to establishment, and even it also vary from state to state. So. So once the regulatory act applies, say example, factories and substance establishment, there are other acts which will automatically follow. Say example, payment of wages, bonus, minimum wages, etc. So and the PF and ESA, it is common. It applies to the organization where as per the applicability. And remittances, everyone knows as it is online and it is essential. So everyone knows that the importance of this. So PF and ESA, it is again central, and PT and LWF, it is state. It is state specific. It means the contributions are not same for one state to another for both PF and LWF. And inspections. There are a number of inspections and notices which is being received by many of the establishment or factories. So state government, say they have the authority to inspect under Factories Act or Substance Establishment Act. And once, as I said, that regulatory acts, once it applies, then there are other acts like minimum wages, payment of wages, maternity benefit, contract labor act, etc. It will automatically follows based on the applicability. So there may be one authority who will inspect for all these particular acts. Second is there are Municipal Authority for Trade License and Substance Establishment Act. That is only in Mumbai where the Bombay Municipal Corporation is the inspecting authority for the Bombay Substance Establishment Act. Otherwise, it is with Labor Department. And there is a separate department for Labor Welfare Fund, and they will also the inspecting authority for the particular state. And there is an inspection by Professional Tax Act. There is now it has been aligned with GST. So a lot of notices which it has been issued by the department in Andhra Pradesh, Telangana, Madhya Pradesh, then Gujarat and Maharashtra. Even Tamil Nadu, it is started. And central government, it is inspection under Payment of Gratuity Act. It is applicable. It is straight away, maybe it may not be, the central government may not be there for all the establishment or factories. In case the appropriate government is central government, then the central authority will come into force. Say it will applicable based on the number of the branches which it is available in more than once in the states. Say example, a company which has office in Tamil Nadu and have a branch in Karnataka, then the appropriate government under Payment of Gratuity Act is central. So otherwise it is going to be state. If even a company has branches, 100 branches in Tamil Nadu, then it is going to be state government. If they have one branch in another state, then the central government will come into place. Then PF and ESA, it is central government. And same with Contract Labor Act, where the controlling authority, the appropriate government is central government for telecommunication, insurance, and banking sectors. So otherwise, it is going to be state government. So there are a number of abstracts it is required to be displayed in the notice board. Say Substance Establishment Act, Factories Act, Minimum Wages, Payment of Wages, Contract Labor Act, Maternity Benefit Act, Employees Compensation Act, etc. So these are the acts where it is required to be displayed in the notice board in both vernacular language and English. And there are a number of notices which is required to be displayed. Say working hours, weekly holidays, then minimum wages rates, paymaster under Payment of Wages Act, gratuity Rule 4 notice, and child labor declaration, no child labor, the declaration is required to be displayed, and national festival holidays, and contract labor working conditions. So these are some of the notices which is required to be displayed. And the name board of the company is required to be there. There is ambiguity where if you see that only the English language will be there in many of the offices, but whereas the vernacular language is a must as per any of the labor law in any of the state. And the local language should come first, followed by English. The font size of the local language should not be less bolder than English. And combined with the employer have the privilege to add any other languages. And procedural part, there are the nominations at the time of joining that mostly the nomination forms are is collected, and then there are weekly holidays. At least 1 day is required to be declared as holiday as per the regulatory acts, and the working hours and rest interval it has been required to be provided to the employees as per the law. And then leave, there are various states provisions available. It vary from state to state again. So the leave provisions are required to be given as per the law. And OT, double the rate of wages are required to be paid for the overtime it is being performed by the employee. But till actually the overtime should not be more than the specified hours. And appointment order is required to be given for all the employees. Standing order, the applicability vary from state to state. Once the labor code, the new labor code implemented, it is going to be 300. But till such time, it is there are different numbers. It is available. Some state it is 50, some it is 100. After the new labor code implemented, then it is going to be 300. So exemptions, it is nothing but the working hours, then the 365 days and any provisions specified in the acts can be exempted by the department, for which the special submission is required to be done by the employer. And policies, all the policies are required to be aligned with the labor law. And the PF Act. The objective of the act is to provide financial security via compulsory savings. So that is objective. It means that it is everyone knows that their interest rate is more than the prevailing rate of the banks or any other institutes in India. So that is being provided to provide a financial security for the employees at the time of retirement. And applicability, it applies to both factories and establishment where 20 or more employees employed. And there are Form 9, Form 11 and payroll logs are required to be maintained regularly. And the UAN is required to be obtained, and the challan is required to be generated, and the payment is required to be filed on our 15th of every month, the following month. So the contribution is, everyone knows that 12% employer and employee contribution, and the liability actually, the important one to notice in case of any any of the violation, only the directors or owners are responsible under this particular act. So the penalties and legal implications, if you see that delayed payment, the interest is interest of 12% per annum, and non-payment, it is penalty from 5 to 25% per annum. And non-compliance, it is imprisonment up to 3 years. So here, for any non-compliance, the employer is liability. Employer means directors or owners or occupier. The terminology used in factories, it is occupier. Otherwise, it is employer or directors. And the illustration, if we see that the employee contribution, it is where there are different accounts and how the contribution have been accounted in PF department. So the entire employee contribution that of 12% will go to a provident fund account, which is account number 1. And the employer contribution out of 12%, 3.67% will go to provident fund, and 8.33% will go to account number 10, subject to 1,800 rupees. The rest it will go to the provident fund account number 1. And the 1%, the employer contribution, where the 0.5% will go to admin charges to manage the provident fund, which is account number 2. And 0.5% it will go to the EDLI, the employees deposit linked insurance, which is account number 21. So earlier there were admin charges even for EDLI, which is account number 22. Now it has been removed. And ESI, the objective is to provide medical, disability, maternity, and other benefits to the employees whenever they are in need. And it applies to any factories or establishment wherein 10 or more employees employed. It applies to the employees where the salary is been drawn less than 21,000 rupees per month. In case if it is a disabled employees, then it is 25,000 rupees. So it means that if you have any disabled employees, then till 25,000 they are eligible for ESI. So that is required to be noted over here. And Form 6 is the employee register. It will be generated automatically from the portal. And there are accident register, which is required to be maintained, which is required to be filed within 24 hours. And wage records, the salary details of ESI contributions are required to be maintained for 5 years. See here, PF actually, the authority has the liberty to check from the date of commencement of business. In ESI, it is going to be 5 years. So any given point of time, the department can ask for the 5 years data. So, and there is a ambiguity. Offerly returns, it is required to be filed, but till there is a provision in the act and there is a provision in the tool in the portal too. But however, actually, like there is no enforcement on this front since it is not been removed from the act. So it is required to be complied. So every 6 months, the return is required to be filed in the portal. It means ESI portal. And there is a compulsory insurance. It is available for the covered employees. It can be done through LIC. Sorry, here I'm just it is compulsory insurance is provided by ESI for all the employees. And there are cash benefits, sickness benefit, maternity benefit, disability, funeral expenses, dependent benefit, etc. So everything is available. So employer is responsible for unpaid medical expenses of employees. In case the employees are not availing the benefit from the department, or in case of any process issues, then the employer is liable. So it means that the benefits are required to be obtained from the department, and for which employer required to help the employees in availing the benefits. Insured person number is required to be generated within 10 days from the date of joining. Other than that, maybe everyone knows about the contribution where the employee is 0.75% and employer is 3.25%. So there is a ambiguity on the basic wages in PF, where the basic wages, the wages definition, it says that basic and the other allowances. So it means that according to our experience and the various judgment, it is going to be fixed gross minus HRA subject to the minimum of 15,000 rupees. So over and above, the employer have all the liberty to remit the payment or deduct the amount from the employees, and it can be remitted. But 15,000 you can restrict it to 15,000 rupees in case if it is over and above. And in case if it is 14,000 or 13,000 rupees, then it is going to be that the fixed gross minus HRA. That is going to be the logic behind the basic wages. And for ESI, it is going to be gross wages. So in irrespective of any allowances it has been paid to the employees, the entire components are required to be considered, except for the component which has been paid within the gap of 2 months, or the rest are all required to be considered. And how again the implications for delayed payment, it is 12%, non-payment it is 5 to 25%, and evasion of contribution, it is 3 years of imprisonment. And if you see, there are it's just a matrix where you have to you can find out the eligibility. There are medical benefit, it is applicable to the individual employees, and sickness benefit, it is individual alone. And the maternity benefit, it is for the female employees. Disability for individual. Funeral expenses, that is for the nominee. And then dependents pension, it is for spouse and children up to the age of 25, or the marriage, the next marriage, which if at all if it happens. And there is an eligibility condition for medical benefit. It is from the day one. There is no limit. Even on the first day, actually, that whatever the condition, the employee and dependents are eligible. See, one is actually, according to my experience, there are a lot of benefit it has been given by ESA, which has been not availed by most of the employees. So the days are changed. See, there are days wherein no one are getting into, no one has get into ESA, but now the benefits are huge. They have the standard has been increased. One case actually, I personally actually encountered where one of the employee was less than 30, and he was admitted in one of the hospital in Guindy, Chennai, for heart attack, and we paid 80,000 rupees as advance, and over the period we know that he is a ESA eligible employees, and that has been reported to the KK Nagar ESA office, and the chief medical officer and his team, they have visited the office, the hospital in Guindy, and they understand that the amount which has been charged by the hospital is not right, and the treatment it has been given by the hospital is, the private hospital is not right, or not up to the standard which is there in the medical terminology. So in the history of the hospital, they have returned the money. In fact, actually, they have asked for another 3 lakhs, and they said that the angio is required to be performed, etc. But when these doctors team visited, and when they scrutinized the documents, they understand that there is no such scenario happened. So ESA, it is now the scenario has changed, and they are providing the quality or high quality medical facilities to the employees. So awareness is required to be given to the employees, by which actually they can utilize the facilities. So minimum wages, it is this act is, the objective is to ensure minimum wage payment to workers and preventing exploitation in for the unorganized employees. If you see, there are the scheduled employments listed under the Act. There are 200 plus scheduled employment. It has been already listed, and once the new labor code has been implemented, the scheduled employment term has been removed, and it will be reduced. So by which actually there will not be any ambiguity in the future. And more, it is applicable to all the organized and unorganized sectors. Under this particular act, the registers, wages register and attendance register are required to be maintained. And there is an annual return which is required to be filed with the Labor Department in the month of January. And remittances, it is nothing but the payment, the salary is required to be paid to them regularly as per the law. So it means timely payment, and that should not be more than maybe that the salary is required to be paid monthly, weekly, or daily. And the notice under minimum wages and the abstracts are required to be displayed. Other important provisions, state-specific wage rates based on skill and industry are available. And then overtime wages, it is required to be paid twice the normal rate. Anyway, that we'll have a separate slide for this to understand what is the ordinary rate of wages. Then wages must be paid in cash, that is through bank, unless agreed otherwise. So the kind is not permissible. Otherwise, stocks, shares, and then the car allowance, etc. That can be provided to the employees. Splitting up many wages components is allowable. Maybe there are very variable judgments. Say Airfight versus State of Karnataka, Hindustan Sanitary Care Industries Limited versus State of Haryana. According to these judgments, there are many judgments, but these two judgments, it says that splitting up many wages components is allowable. And penalties in case of less than many wages paid, then it is the fine, and then the back payment of wages with 10 times are required to be repaid. Then for non-compliance, it is going to be 6 months imprisonment and or fine of 500 rupees. So Labor Welfare Fund, it is again one of the Social Security and Welfare Benefits Act. It also provides social security and welfare benefits to the workers. where this the fund, whatever it has been remitted to the department, they are using it for housing loan, education loan, and medical care and recreation. And the applicability varies from state to state. If my memory is right, then 14 states are applicable, and the rest of the states it is not applicable. And again, it is applicable to all the factory, commercial establishment, and the industrial workers who are drawing salary of less than 10,000 are eligible to avail the benefits under this act. And there is a register record to be maintained. That is employee contribution register. Then there is a returns. There are monthly, half-yearly, or annual returns. Monthly is in Kerala. Half-yearly it is Gujarat, Madhya Pradesh, West Bengal, Maharashtra, etc. And there are annual returns available. Say Tamil Nadu annual, Karnataka, Andhra is annual, etc. And contribution, it is again vary from state to state. There is a employee contribution and employer contribution. That is required to be remitted to the concerned department along with the returns. So displays the contribution details are required to be displayed. That is unpaid accumulation. Also, it is required to be displayed in the notice board. So unpaid accumulation is nothing but any wages, any bonus payment. It is not being paid to the employees or not claimed by the employees that are required to be remitted to the Labour Welfare Fund Board once in 3 years. And again, it is a non-payment penalty and interest as per state rules, and misuse of funds, legal action against employer. That is only it talks about the unpaid accumulation, where unpaid bonus salary that is required to be paid to Labour Welfare Fund. And for failure to maintain record, there are fine and imprisonment in some states. Payment of Wages Act, it talks about the timely and full payment of wages without unauthorized deductions. So it is applicable to the employees who are drawing salary of less than 24,000 per month. And again, it applies to factories, railways, industries, and other specified establishments as per ID Act. The applicability is been you have to refer ID Act to find out the applicability. And there are again the wages register, deduction, fines, OT. So all these registers are required to be maintained under this particular act. And there is an annual return. It is required to be filed. And remittance is nothing but timely wage payment to the employees. And it talks about how it is required to be paid, whether it is being paid through bank, whether it is paid through kind currency, what currency is required to be paid. So all these provisions are mentioned in this particular act. And displays abstracts of the act and the deductions, whatever it has been deducted as fines or other deductions, that is required to be displayed in the workplace. And it talks about the salary date, the pay date. You know that one is in case if the total employee count is less than 1,000, then it is 7th. The pay date should be 7th. Maybe the employer has to pay the salary before 7th. And if it is more than 1,000, then they have the privilege to pay till 10th. But it should not go beyond 10th. And wage period shall not exceed 1 month. So the monthly salary is allowed, not bi-monthly or quarterly salary is not allowed. And there are deductions. It is allowed, but depends on the provisions which is available in the Act. So penalties and legal implications, it is delayed payment. Again, same, it's a fine is there. And repeat offences, then there will be imprisonment. So bonus, it is the objective is to provide a lump sum amount at the time of festival to the employees. That is like the profit sharing to the employees by the company. So the infancy period is there where they have the last making company for the first 5 years, they no need to pay bonus to the employees. But after 5 years, even in case of any loss, they have to pay bonus to the employees, irrespective of whether they are making profit or not. And it applies to the companies where 20 or more employees employed. And the employees who are drawing salary of less than 21,000 are eligible for bonus. Complaints front, there is a bonus register. Form C is required to be maintained. And Form A and B, it is a financial part where it will come out automatically from the balance sheet. And then annual return is required to be filed. And bonus is required to be paid within 8 months from the date from the financial year end. So it means before 30th November, the bonus is required to be paid. And return is required to be filed within 30 days from the bonus paid. So it means December 30th is the due date. And if it is online, then the February 1st is the due date as per the recent the notification it has been released. And how to calculate bonus? It is 7,000 or minimum wages, whichever is higher, into number of months worked into percentage of bonus. So this is a standard formula for calculating the bonus. And minimum bonus can be 8.33% and maximum can be 20%. But however, it depends on the amount it is available in the allocable surplus. So based on the profit, certain amount will be allocable for bonus through accounting terminology. It will be done. So based on that amount, it can be the percentage of bonus can be decided. It all arrived from the profit of the organization. And eligibility is the employee who are worked for at least 30 days in the previous year are eligible for bonus. And pro rata, the bonus can be paid by pro rata. So it means number of months worked. So even number of days also you can prorate. And again, penalties and legal implications: non-payment, fine of 1,000 rupees. False statement, in case of any false information to the department, then it is going to be 6 months imprisonment. Repeated violation, then higher penalties and legal action. See, Payment of Gratuity Act. The objective is to provide a lump sum amount at the time of retirement. But however, actually, you know that today everyone is moving or jumping from one company to another, and by which actually they are not getting the enough benefit as per the law at the time of retirement. And it applies to the establishment where 10 or more employees employed. And applicable to the employees who are completed 5 years of continuous service. Form A is required to be filed at the time of commencement of business, and there are the gratuity is recorded through Form I, J, K, L, M, N. Depends on various parameters. And there is annual returns. It is only in one or two states where it is required to be filed. And the gratuity is required to be paid within 30 days of eligibility. And there is a notice which is required to be displayed. It is in Rule 4, and the abstracts of the Act is required to be displayed. And the formula is last done salary into 15 days into number of years of service divided by 26. So this is a formula for arriving gratuity. And there is a compulsory insurance which is required by the employer through Life Insurance Corporation to protect the interest of the employees. Maximum gratuity payable is 20 lakhs. And there is a judgment in Tamil Nadu. It says 4 years and 240 days. It means that the eligibility is 4 years and 8 months. 8 months. So I think Surendra Kumar Verma versus Madras High Court, through which the judgment has been arrived, and it says 4 years and 240 days. I think he was worked for 4 years and 248 days. And the judgment has been given in favor of the employee, by which now it is the 5th year shall be considered as continuous service, and it will be deemed as 5 years, and the gratuity is required to be paid. So though there is no other judgment in other states, but till in case of any employees, if they approach the court, then with that definition of 240 days, the similar kind of judgment will be provided. So it is better the moment the employee is completed 4 years and 240 days, the gratuity is required to be paid. And delayed payment, the 30 days, the gratuity is required to be paid within 30 days from the date of the retirement or termination of employees. So in such case, in case of 31st day, then the 31st day, 31 day interest is required to be paid to him. It is one is the interest is required to be paid to the employee, and second, actually there is a fine which is there up to 10,000 rupees for the non-compliance. Equal remuneration, another important law where it is equal pay for men and women for the same work or similar nature of work is required to be paid. See, the employer is having all the rights to um, give higher salary for the male employees in case of qualification, performance, or any other category, but it should not be on the gender based. The discrimination should not be there. Otherwise, you should have proper documents when you pay higher salary to the male employees. And again, it applies to all the establishment industries and employees in India, and all employees. It includes contract employees, so irrespective of salary which has been uh, paid to them. And there is one register it is required to be maintained, which is it was Form D, and now it has been changed to Form B. So that is required to be done. Otherwise, even in recruitment or promotions or training, there should not be any discrimination. And in case of any wage discrimination, it has been proved, then the fine is 10,000 rupees. And any other violation, it is there is imprisonment. So again, the objective is to regulate the working conditions and to provide safety, health, and welfare to the workers. It applies to the factories where the applicability is 10 or more employees with the head of power, then it is applicable. And in case of 20 or more workers employed and without power, without head of power, then it is again applicable. So the applicability is 10 or more workers with head of power, 20 or more workers without head of power. So that's applicability on the factories front. And it covers the manufacturing units across India. And there are multiple registers it is required to be maintained, which anyway that we are also having one more slide on this. There is a an online return, it is required to be filed in Form 22. If it is a manual, then it is going to be Form 21. And there is a display, factory license, health, safety policies, emergency contact numbers, and accident procedures are required to be displayed. And working hours, it is maximum of 48 hours per week and 9 days per day, with a mandatory weekly office record to be provided as per the provision. And in the OT pay, it is going to be twice the rate of wages, the ordinary rate of wages. And health and safety, it is clean drinking water, ventilation, safety gear, and first aid is required to be provided. And the manufacturing process, it is there should be an input and the output. There should be some process should happen, and the transformation should be there. And based on that, there should be output. And only then actually it will be treated as a manufacturing process. Ordinary rate of wages, it is normally it will be treated as the fixed wages, whatever it is being paid to the employee as fixed wages, will be treated as the ordinary rate of wages, or will be deemed as ordinary rate of wages. So bonus it should not, bonus is not, bonus is excluded. OT wages for OT is excluded. And in case of any the provision on the coupons which is being provided to the employees, that also excluded. So it means fixed wages other than anything paid as a coupons or any other concessional sale, that will not be included. And registration, there are everyone knows that there is a license required to be obtained, and the procedure is maintained. It is mentioned over here. So no premises shall be used as a factory. So without registration and license, so that is mandatory. So this is required to be done at the time of before commencing the manufacturing process. So just a process which it has been mentioned over here, and I'm just skipping it. And different forms, the registers are required to be maintained. The form 7, form 10, 12, 15, 25, 18, 28, 29. So these are all required to be maintained by any of the factories. And the forms followed. And here occupier is the occupier shall be one of the director. So factories, the definition says only the occupier is called as an employer, who is maybe it says that who is having ultimate control and affairs over an establishment is called as occupier. So ultimately it is going to be one of the director. Maternity Benefit Act. The objective is to provide maternity leave and job protection to female employees, and it applies to an establishment where 10 or more employees employed. It applicable to the woman employee who has completed 80 days in the last 12 months. And there are register record to be maintained and annual return record to be filed. So the paid leave with wages are record to be paid based on the last done salary to the eligible employees, and the abstracts is record to be displayed. And everyone knows that 26 weeks for the first 2 children is record to be provided as maternity leave, and 12 weeks from the third child. So no termination or dismissal during pregnancy or maternity leave. Termination is not required to be allowed at the time of pregnancy or when she is on maternity leave. And there is a penalty penalties and legal implications for non-payment of benefits. So in case it has been not paid to the employees, then fine is there. And in illegal dismissal, then it is an imprisonment. And failure to maintain records, there is a legal action and penalties. See, Contract Labor Act, again, it's ocean, but I'll try to cut short it. It is again to regulate the employment of contract labor and ensure their welfare provisions. And there is one more is the abolition. I think Section 10 it talks about the abolition in certain conditions of the contract work. And applicability, it applies to an establishment where 20 or more contract workers employed. And even for the contractors, when if they supply more than 20 workers on any day in the preceding 12 months, then it is applicable to them. And the number varies from state to state. In AP Telangana, it is 5. Gujarat, it is 10. Maharashtra, it is 50. West Bengal, it is 10. Otherwise, it is 20. And there are now list of contractors. It is required to be maintained by the principal employer, and for the contractors, they have to maintain various registers like wage register, attendance register of fines, OT, etc. And principal employer is required to be ensure the complaints of contractors. And principal employees are required to be filed hourly returns, and principal employer is required to be filed annual return, and contractors required to file hourly return. And displays the abstracts and the notices are required to be displayed in the notice board. And there are certain activities are prohibited. However, actually the terminology can be changed while applying the registration certificate or license with the department. So most of the role or it is almost equivalent to what the regular employees are doing it, but till the terminology has been changed based on the requirement of the nature of work entrusted to the contract employees, by which actually you can come out from the abolition. So there is a penalty. It is non-compliance by contractor. The principal employer is held accountable. They have primary responsibility, and the contractor is also having the primary responsibility. So Substance Establishment Act, it is similar to what factories where it also the objective is to regulate the working conditions, wages, employment terms, and welfare of employees. Again, in, all the shops, offices, hotels, theaters, and commercial establishments are fall under the applicability category. It applies to both organized and unorganized sector employees. So there are returns and registers required to be maintained and displays the abstract of the act is required to be displayed and working hours are required to be displayed. And there is a leave and all it is which we have seen. And violation again is fine of 500 per offense. And again it is vary from state to state. It's Option Establishment Act is it is a state law where it vary from the provisions, the penalties and legal provisions vary from state to state. And then the formats of registers and then the returns are also it is vary from state to state. Otherwise, leave but every act this act is in every state is to regulate the working conditions and employment of the employees. So that's a major objective. The final one is Employment Exchanges Act, where this act is to notify the vacancies to the employment exchanges, but you no need to maybe provide the job to the candidate which has been referred by the employment exchanges, but till it is one of the complaints which is required to be done. So it applicable to the establishment wherein 25 or more employees employed. And there is a quarterly return record to be filed ER1 and ER2 was there. It has been removed, but it is not been notified so far till the enforcement is not there today. But however, actually that one is whenever there is a vacancy arise, it is required to be notified. And once you close it, the closer also it is required to be notified. But as a date, the enforcement is very less, but complaints is required to be done as per the law. And the penalty is 1,000 rupees per offence. So that's it from my side, and we'll get into the question Q&A.
Thank you, Ravi sir. And some of our participants have questioned on the chat box, so we could start the QA session, sir.
Yeah. See, digital records of the registers. See, there is a Information Technology Act. It has been formed in the year 2000. It says that any record in India can be maintained in e-format. So that through which actually it can be maybe referred to any of the authorities. And it has been accepted by most of the authorities, but till there is an ambiguity because of which there are governments they started issuing notification on this particular front. But however, actually this is there since 2000. So it is digitalized. Someone has asked for the cash payment, but cash payment it is nothing but it is through bank. See, only in kind it is now it is not there, and that has been it was there in the presentation too. Yeah, percentage of bonus it can be vary, but it depends on the available and allocable surplus. If you have the amount the available surplus, then definitely actually you have to pay more. It can be even maximum. In case if it is less than that, then see you should not have maybe you can keep you cannot have the excess amount with you by declaring 8.33%. It should be you have to utilize the fullest amount that is available. Okay, allowances, yes. See, not all the allowances are maybe the question is allowances not included for ASI, but it is only the allowances which is being paid really to say like a uniform. It is if at all if uniform has been provided and they are replacing it, say and there is a uniform that washing allowances, then yes it is. But otherwise, if you are giving any special allowance, any city compensatory allowance, yes that and all it is required to be considered for ASI. That will be deemed as wages under the Act. So if you have any specific one, then it can be maybe if you have any specific components in mind, you can raise it. Then we can tell that whether it is uh, fall under the wages definition or not. See, gratuity. See, if you see that, if you ask whether maybe I'll tell you the question. The question is, can gratuity be part of CTC? Uh, See, gratuity, it is as per the statute, it is required to be paid. It is mandatory, and it does. If at all, if it is there in the CTC, then even the employee is employed for 1 year or 2 years, then you will end up paying the gratuity to them. So because it is because you declared that it is the cost of the company to the employee. So if you ask me, my suggestion is it should not be there. It should be actually, you can say that the gratuity can be gratuity as per the applicability or something else. You should have it. The uh, you should have some maybe you can add it just to attract the talent or attract the employees. You are mentioning it in the CTC, but in the bracket actually you can mention that it is applicable when the employee eligible or when the employee is employed only as per the applicability of the act. So by which actually you can come out of the liability. Otherwise, yes, it is going to be the liable for you. Okay, a definition of wages for bonus calculation. Wages means it says all remuneration, but again basic and DA. There are ambiguities. Safest side is to consider only basic and DA, as there is no judgment or sometimes actually that authorities are accepting everything. Sometimes actually they are not accepting it. So better actually you consider only basic. Anyway, that you are paying ex gratia to the employees. So better actually you consider this those employees and pay and provide bonus for those eligible employees, and the remaining as gratia, by which actually you will not have any issues. Yes, employees. Okay, employees earning about 21,000 are not eligible for statutory bonus. It's a question it has been raised, but yes, it can be. You can pay that as gratia or performance bonus. Okay, one question is, can we pay PT for all employees across India in the head office, which is in Tamil Nadu? So PT is the local law, and it is required to be paid to the respective location. So hence, it cannot be paid in Tamil Nadu. Okay, what are the registers or records to be maintained by company registered under Shops and Establishment Act under the Payment of Gratuity Act? See, one is Form A, it is notice of opening. And there is a nomination forms which is required to be maintained. You have to obtain for all the employees. And the gratuity eligible employees record. So Form I and L you have to prepare, and the submission copy is required to be filed. And then the payment which is being paid to the employees, that proof is required to be kept with you. Display, yes, it is. There is no exemption. The question is whether is there any exemption for the abstracts and notices to be displayed, but no, there is no exemption. Probably in what way you have to display, that is that you can decide, but you cannot evade any of the task. So all are mandatory. Can the appointment letter to be digitalized? Yes, it can be digitalized. You can send it, but you should have all the proof. Now it is, as I said, that Information Technology Act Section 4 says any record in India can be maintained in e-format. Which allowances under gross wages or salary not considered as gross wages? Okay, that is. Okay, when will be the code on wages be implemented? Yeah, we are also waiting eagerly. But it may, but 25 states they have released their rules, and only West Bengal, Mizoram, Nagaland, and one more 4 states actually it has been pending. That will be released. But the government has given time to them, and they have promised the government, central government, that it will be done shortly. And what we are expecting is that it will be notified by the central government, and they will give time for the state government to maybe for 6 months time or 1 year time will be provided for the state government. That is what we are anticipating. Otherwise, there are meetings. It is happening every month. From the concerned stakeholders, they are meeting every month, and there is a press release. It has been released. So any time it can be, but not before 6 months. That is what we are anticipating. Thank you, everyone. Thanks for the interest shown with us.
Thank
And
you.
keep wait for this on the page where you will be getting more interesting topics in the future.
Once again, thank you, the team, also the participants who are interested in this webinar. It is not a closing session. It's a start session. You can contact us any point in time to get in touch with the things. So we are really ready to answer all the questions and queries. Also, we are here, LCS team, to support any statutory requirements or any other solution requirement. We are happy to assist organizations and HR leaders in all respect. So thanks once again. Thank you all. Thanking for your participation. We will definitely get all the content of this meeting. Also, the answers will be given to you. Also, any other critical issues you have, and we as a team will support you in all respect. Any of things for the organization as well as the HR leaders. Thank you. Thank you all.